Just going to make sure that I am in fact live before I start doing this in earnest, because I am not the smartest or the most technically savvy person in the world. And yes, there are chickens. Enjoy them. It's the first sunny day here in quite a long time, so I'm enjoying it outdoors, and I get to do that because I'm almost a full-grown man. So a few days ago, well, more than a few days ago, somebody told me that this guy, Lane Meyers, they told me that he had fired A. Blair Dunn. Now, A. Blair Dunn, for those of you who aren't in the know, is a attorney who is out of New Mexico. He's done a lot of cases for libertarian kinds of clients. He's currently representing James Springer, colloquially known on the YouTubes as James Freeman. He's representing Freeman in the lawsuit against the 6th Judicial Circuit. Let's see, Springer v. 7th Judicial Circuit. He's also representing Springer in Springer versus Grisham. Let's take a look at those. Let's see how he's going. While we're here, if we're going to do it, let's do it right. See if I can't actually do this court listener. There's Springer versus 7th Judicial District. Let's see how the appeal is going. I don't think the sure, instead this is the see how the appeal is going. That's the appeal number, and that is the 10th, I think. 10th Circuit Court of Appeals. All right, so the brief, so they lost at the trial court level. They lost on a motion to dismiss, and so right now the opening brief for Springer is due on February 20th, and then in Springer versus Grisham, court listener. Springer v. Grisham. There's oral argument in Springer v. Grisham on January 21. And what's the docket number? And let's see if there has been any. So he lost. I kind of suspected he would. So he lost. Springer lost his motion. Oh no, the defendants lost. Well, that's interesting. I did not expect that. So there you go. I thought that Springer had lost on that. Oh no, wait, that was last year. So yeah, so this is hearing from the. Gotta be smarter than court listener, John. This is the oral argument. They haven't filed a opinion yet. I did listen to the oral argument. I want to say that Blair Dunn does well at oral argument, or at least I think he does well at oral argument. What is this? Oh, he does well at oral arguments, but the problem was that I think he gave, I don't remember exactly what it was. I did listen to it. 2-3 weeks ago. Essentially, I believe he said that there was no jurisdiction. I think Lane actually gave up that there was no jurisdiction there was no harm, that there was no case or controversy between them. So I have a feeling. And then there was another case that is pled basically on the exact same lines for the exact same reasons. And the 10th Circuit Court of Appeals in that case denied it. And one of the grounds was that there are other laws in place at the county or city level that prevent people from carrying in the same parks that Springer is wanting to carry in. And so, am I live? Yes, I really am live. So basically it was moot, even if the court granted the relief requested, staying Governor Grisham's order about the carrying of the firearms in those places, there would still be another statute or ordinance that was preventing you from carrying in those places. So it's basically a moot kind of point. So A. Blair Dunn is an interesting kind of guy. And again, remember where I found him was he was representing Springer on the 7th Judicial District, and his pleadings drove me absolutely apeshit. And his nonsensical ramblings where he confused political arguments with legal arguments, I thought was also pretty inane. And I also thought the opposing counsel in that case, the counsel for the judges and for the 7th Judicial District Court, was also a fairly terrible attorney as far as I could see. But anyways, that's kind of Blair Dunn. Now, I was told in a comment, maybe I could find the comment. Let's see if we could find the comment. Let's go to your videos. Comments previously. All right. So there's this comment by Glanton Gang 2 that told me that Lane Meyers fired A. Blair Dunn. So I asked for anything about it, and I didn't get very far. But then I asked, after getting tired of waiting, I asked on my Discord, and I got a case number and a link to, I believe it was this video that's currently up on your screen, but I'm looking for the case number right now. It wasn't back that far. Let's try a little more recently. Oh, I'm in the wrong spot. Don't you hate it when you're in the wrong spot? That's what she said. Wonka wonka. Here we go. Lane Meyers. There's the case number. So let's see if we can't pull the case up. New Mexico. Look up. And it was, what was it? It was M33MR. I am not a robot. Case number search. M33 33MR. And then what was the remainder of it? Because I have the retention of a squirrel. 2024 00017. 00017. Case number search. No results found. M 33MR 33MR 224 Case number search. There we go. So this is the case that's currently being prosecuted against Lane Meyers in New Mexico. And I just want to make everybody clear that I am not an attorney in the state of New Mexico. I'm a lawyer in the state of New Mexico, but not an attorney. Is there a difference? Yeah, there is, but not a lot of places actually keep track of the difference. And the terms are pretty much synonymous now. But I am not licensed to practice. How about that? I'm not licensed to practice in the state of New Mexico. So I don't really understand how to read this very much. I do know that 3014-1B is trespassing. I know that 30-14-1C is also trespassing. I believe B is where the owner tells you, you know what, let's look it up. And C is where the state tells you. 30-14. 30-14-1. New Mexico. I'm going to assume this is close enough. It says it's for 2024. I'm going to assume this is the current version. Remain on the other when the owner or occupant thereof. Okay, so yeah, so basically if it's posted or if they tell you to get off their property, the owner, or I'm going to assume that it would also be the agent of the owner or an authorized representative of the owner can tell you to get out of there. And then C is where it's lands owned, operated, or controlled by the state, or it's any of its political subdivisions. So my understanding was, ooh, that was a nice bite. Oh, skeeters. My understanding was, at least, well, maybe I'm getting ahead of myself. But my understanding is that he was trespassed from federal property in New Mexico. But maybe I'm getting ahead of myself. Yeah, maybe I am getting ahead of myself. But I do know that part of the controversy between Lane Meyers in the video that we're going to go over today is between whether he's being charged with B or C. And looking at this, it looks like he's charged with both, although I'm dumb and retarded and I don't know that he's being charged with both. It may be that they're charged in the alternative, or it may be that he was charged with one and now he's charged with the other. But Lane seems to believe that he's being charged with this, and Dunn seems to think that Lane is charged with this. Despite any of my misgivings about Dunn, I think he is almost certainly competent enough to know which section of a trespass statute his client has been charged under. And so I'm going to defer to his greater understanding than Lane Meyers for reasons we'll see. Now, if you aren't familiar with Lane Meyers, this guy is like, he's a handful. Boy, howdy. Just out of curiosity, am I coming through? I know I have a few people watching at this point. Is there any problems with the audio before we get into this? Just kind of maybe I'll play it if everybody's just listening while their hands are full, jerking off to the to my beautiful visage, because we know people love jerking off to the oh, there we go, my beautiful visage. Moderation makes everyone feel safer. No, moderation is not going to make me feel safer. And there everybody is. Okay, must have just been a time delay. All right, so we're going to get into Lane Meyers. Lane Meyers is you know, I'm not a psychiatrist or a psychologist, but I would not fathom a world where he is not psychologically or emotionally unsound. The guy, I can't say he's crazy, but he's knocking on the door real hard at every conceivable level. I would not want to interact with this guy in the real world. I would not want to have him as my client. I would not have him as my client. I'm not entirely sure that he should be out in the world. And I say that not to be mean. I say that because I don't think he's capable of handling it. Alpha Fox Adam says he claims he had a TBI, checks out. Well, apparently he also claims that his wife is either a federal attorney or a magistrate or something like that, which doesn't pass my particular sniff test, because apparently, allegedly, he also claims that he lives in his parents' basement. So I'm not going to take anything he says as truth. I don't know that he's actually moored enough in reality that we can trust what he says to be true. Although apparently he has quite a fan base that seems to think that he's something special. Speaking of Frauditer Wrangler, apparently Frauditer Wrangler is in custody, and yay. All right, so we're going to go with Lane's Lion Legal Losers, which he published 4 days ago. Now, I do want to point out, again, I go back and forth on all this stuff, and I apologize, but there was a motion to withdraw that was done on the 29th, and so you have a Sixth Amendment right to counsel, and that Sixth Amendment right to counsel is a right to effective counsel. Now, she was a Fed clerk or something. He has a paralegal degree from prison, according to what he told the court. Well, again, if you're relying on what he said, I'm going to press X to doubt. So it's a huge X to doubt. And yes, that is my understanding. I watched Sarge, or what's his name? Oh God, why can't I remember it? Master Sergeant, MSG, and I watched Josh. I can't remember what he's going by now. He keeps changing the name. He used to be Platoon Hard Drive, but he's something else now. All right, so I'm aware of that. So I can't. I'm not going to trust anything he says. So I've heard various stories that people say that he said his wife was a federal attorney, a federal magistrate, now a federal clerk. So I mean, pick one story and stick to it. And even if he is married, and B, even if his wife even is a lawyer, you don't obtain legal knowledge by sleeping with a lawyer. That's not how legal acumen is transferred. I didn't fuck all of my law school professors to be able to understand how to interpret statutes. So, even if he is married to a lawyer, I mean, he's not Felipe Hemming. So, I mean, it's not something that's passed through the transfer of genetic material. All right. So, and yes, hashtag all. All right. So anyway, let's do this. It's this one right here.
Hello?
Don't say anything and let me talk.
For sure.
Okay, I just want to start this off with, he is making a phone call to his attorney to discuss strategy, tactics, how they're going to progress in the case, how they're going to handle the case coming forward. And he, number one, recorded it. And number two, published it. He completely obliterated any claim of attorney-client privilege that anybody could ever assert, at least about everything raised in this. Everything raised in this. Even tangentially, I mean, it opens the door for everything. I'm assuming that New Mexico's evidentiary rules on attorney-client privilege are similar to the federal or California ones. But holy shit, like, what a terrible move. Number one, as far as defending your case. But as an attorney, I would fire my client if he did this to me. I just would fire my client if he did this to me. I would instantly prepare, file, and serve a motion to be relieved as counsel immediately. All trust is lost. All trust is lost. You can't do that. Now, it appears that he published this after the attorneys withdrew. So that might be a mitigating factor, but I just want to say that even if that is the case, everything that they talked about has been made public. So there's no attorney-client privilege anymore on basically anything that touches any of the topics that they discussed here today. Does he have the same lawyer after this? I don't believe he does. It does not appear he does, because again, the motion appears to have been granted, and the party type was D for the motion to withdraw as counsel, and the party was 1. So there's only one party. Party D1 is Lane Meyer. Apparently, we're going to be serenaded, and I do apologize about that ahead of time. All right.
You're damn fucking right. It was embarrassing. I've never had a fucking client ever do that to me before, and I will never stand for it again. So if you're ever fucking playing, I'm going to pull up this call. If you ever do that again, I promise you, if you even have any inclination you'll ever do that again, you will never get me to represent you again on anything else. I don't think Jerry differs from me on that. I'm not going to put up with that shit. You were told not to say anything, and you still interjected multiple times.
So when you're represented by counsel, you're not supposed to say anything unless and until your counsel asks you to say something at a hearing. There may be a time where your counsel might say to you, or might say to the court, I think my client would be better at addressing this particular factual issue, whatever it is, than I would be. And your attorney might ask you, the client, to say something at the hearing. But you are represented. The point of having an attorney represent you is so that you are represented. Your attorney is speaking for you. So you got to let him do his job. If you're not letting him do his job, then there's a problem.
It was embarrassing. You made it worse. Lane, what you kind of need to understand is that what you did hurt us a lot legally.
Well, see, someone says he should be in jail. It just jumped. He's trying to be edgy or something. Like I don't know, but he's doing this to make a statement as if anybody can understand what he is saying, other than being clownish. He looks like a clown. He acts like a clown, and people treat him as a clown. So, I mean, if that's his goal, it's working really well.
Because what you're doing is you're arguing with the judge, and you're telling the judge that you don't have confidence in our representation.
That's 2 problems. Number 1, arguing with the judge is never a good idea. You should make your argument. Your attorney should make his argument. Your attorney should argue the case to the judge as much as is proper and in a polite fashion. But you should never tell the judge that you lack confidence in your attorney, or second guess your attorney, or tell your attorney is wrong. That should be handled outside of the courtroom between you and your attorney. If there is a problem, if you are a criminal defendant, then you should ask your attorney to step aside, and your attorney will bring the motion to be relieved as counsel, or hire a different attorney and let your existing attorney know. But it's not a thing where that should be aired out. That's not a public thing to air out. You know what I'm saying?
And that you think that you can argue this better. That's the perception she's going to get. So what you did really harms both mine and Blair's ability to represent you, because you're making us look like you don't trust us and that we don't know what we're doing.
I respect that.
And if you don't, and you think you can do better, I'm happy to step aside and you can handle it.
No, it's not bad. It's just that I don't understand why there was no ability to steer the court back to state issues when you're sitting here. I'm not charged with that. So why didn't somebody just say he's not charged with that?
Well, hold on. We did.
All right.
She started off with her mind made up that there was nothing.
For sure.
I agree that.
Now, one of the things that I have a problem with is if you're having a conversation with someone and you ask them a question, you say, I don't understand X, and then they go in and start explaining it to you, don't cut them off. Let them explain it. I mean, if you don't understand it, if you really don't understand it, and you're essentially saying, I don't understand this, you're essentially saying, please explain this to me, let them explain it.
There might be something out there she's missed.
All right.
We got that.
All right.
But you nearly fucked that up. Okay. That's the problem.
I get you. No, I respect that we can have these conversations, like the 3 of us can have these, and I should have just shut the fuck up and let us argue between each other. You know what I'm saying? Not argue, but you know what I'm saying? Like.
No, you should not argue with your attorney. You should not argue with your attorney. You have hired your attorney because your attorney is, for lack of a better word, an expert, someone who understands the process, the procedure, the law. Your attorney is there to hold your hand and guide you through the process. Maybe you'll win, maybe you'll lose, but your best chance of getting your evidence in front of the judge, your best chance of keeping their evidence from being in front of the judge or jury is if you have an attorney who understands the rules of evidence, an attorney who understands what is and isn't relevant, who understands what the essential elements of any crime are, etc. That's why you hired the attorney. You don't argue with the attorney. If you know more than the attorney, so typically, I get wound up listening to this, and I apologize. But typically, in my experience dealing with other attorneys on criminal cases, typically a misdemeanor case, something like this, you pay a set sum of money. And that set sum of money is based on the lawyer saying, this is going to take this much time and this much trouble. So I need this much money to represent you from A to Z on this case. And a lot of times it's not even from A to Z. A lot of times it's from A to trial and then another retainer to go through trial. So the first retainer would be like for motions to dismiss, motions to suppress, etc. And the second retainer would be actually to go through trial because maybe you actually get this resolved before trial. But it's a flat fee, and that fee is based on the attorney's understanding of I need to do X, Y, and Z. These are the steps I need to take. This is how much time it's going to take me. This is how much money I need to make to get there, to pay for my time. And if a client wants to come in there and try to change the flow of that when there is a fee schedule in place where it's a set fee, then that destroys the attorney's calculations. Now he's spending time. And time is money. When you're an attorney, that billable time is money. Now he's spending his time arguing with the client, not making money, arguing with the client. It's unbilled time that he did not calculate into his final. So you're not helping anything. The attorney's not going to think that you, not an attorney, know better than the attorney. I have represented 4 attorneys. I've represented 4 attorneys in my career so far. And the only way I was able to represent those attorneys effectively was they said, I'm going to let you do it. I'm going to follow your direction. I'm going to keep my mouth shut, and we're going to go along with whatever you have to say. And that's the way it has to be. Too many cooks spoil the soup, all that fun stuff. Shut the fuck up. Don't argue with your attorney. Don't argue in private. If you have a question, sure, ask, make sure you understand it, but you're not arguing with your attorney. You accept what your attorney says. So Lane doesn't understand the tactics or the strategy, I don't know which one would be the correct word, that Dunn is using, but Dunn does. Dunn has a goal in mind.
That's all we're asking, right? Is that when you have questions?
I honestly didn't know it wasn't muted at first, and then I was like, oh, fuck, and then I was like, and then I hit it, and I'm like, fucking my ADD's kicking in, and I'm caught in the middle, right? And but ultimately my loyalty.
You're not caught in the middle, bro. You are the defendant. It is your job to shut up. If you are incapable of successfully shutting your fucking mouth for the duration of a hearing, then you've got a problem, and you don't have any attorneys. So
is to you two, not to her or the court, or you know what I'm saying? And so that's why
I told Blair the second she started talking to us, I told Blair she's going to argue the state's position. She literally
exactly.
made up
Thank you.
The second we started, and I text Blair immediately saying, yeah, I knew where it was going to go because Blair and I could tell from the second she started up. She didn't care what we had to say. She didn't care what emotion said. She didn't care any of that. And that's fine, right? Because we've always been.
So he's saying that they're arguing, she's going to argue the state's position, but then he also says it's their motion. So this is the defense's motion. I'm going to assume it was one of the defense's motion to, let's see. It was a motion. I'm going to assume it was either a motion to suppress. It could have been something else. So the moving party, you see the moving party on this one is the defendant. So the burden of proof, the burden of maybe not proof, but the burden of convincing the court is on the defendant. It's their motion. So you need to convince the court. So yes, the kind of default position that a court normally takes is that the non-moving party's position is the bench. It's like the benchmark. That's you've got to move the judge from the non-moving party's position because you're asking the judge to affirmatively do something. The defense is saying, don't do anything. And so you bear the burden of proof. So I understand, like I get that Dunn and the other attorney on the case, they're trying to put it in simple terms that maybe Lane can understand, but you got to understand that like it doesn't mean that the court is against them. They're the moving party. They're asking the court to do something affirmatively. They bear the burden of convincing the court that the law and the facts support what they're asking for. So Lane is now confusing what goes on at motion hearings. The burden of proof of any relevant fact is not what's going on in a motion to suppress. It's a legal argument that is taking certain facts that are either uncontested or the court is going to have to make some findings of fact, but they're not findings of fact for trial about the credibility of whatever. And so the court's going to be looking at these things, but it's not an evidentiary hearing where the people are trying to ultimately prove facts, if that makes sense. You're going in there on pleadings, on papers, with affidavits, with exhibits, maybe a video or something, and you're saying, look, I want to suppress this evidence because you can see for X, Y, and Z reasons. It's more of a legal argument than it's going to be an evidentiary argument. So him saying that, like, oh, the judge is arguing what's in her mind. No, the judge is probably saying, well, the prosecution has shown that that these facts, and so I've got to kind of make a decision between whatever contradictory facts you guys are saying. But my default is going to be the non-moving party side. Lane put up documentation from a Forest Service handbook that camp host absolutely no legal responsibility or duties and not allowed to do anything legal. Okay. I don't know what that has to do with the price of rice in China, but okay. So just so everybody's aware, when he says appeal, it's a trial de novo. Essentially, it's the magistrate court. My understanding of the magistrate court is that it's not a court of record in New Mexico. So the trial court, the magistrate court will make findings of fact. They'll render an opinion, a decision. If you don't like it, you appeal, in air quotes, to the district court, and you get a whole new trial. You have to present all the evidence again, yada, yada. So he was saying that because camp host was the one who trespassed him. Okay. But again, what does that have to do with the price of rice in China? That's saying you have to get out of here. That's not taking legal action. The camp host didn't file a lawsuit. The camp host said, no, I want him out of here, to the police. He trespassed Lane, saying, you're not welcome here anymore. You're not allowed to be here. And the police took him out. I don't know. I don't know what the price of rice in China is. I don't know. It's a great question. Even this shirt is wrong. Public landowner. No particular member of the public owns any share of public land, period. You're not charged with a violation of the regulation in the Code of Federal Regulations. Oh, shoot. You didn't hear any of that. Oh, poop.
Motherfucking CFRs is in fucking federal court.
Hold on. But the CFRs are the ones that we put in there, which means that she went to those and said, well, it doesn't say here that a volunteer can't make that. we have to shore up where it says who has the actual authority to trespass somebody for
But
federal.
hold on, but she's saying, but this is what I don't understand, you guys. You guys put this. So she says, I looked at the CFR and there's this one for threatening and shit. So why the fuck am I not charged with that? Why am I charged?
Which doesn't sound like something a magistrate would say, because again, a magistrate judge in New Mexico State Court, the state court system of New Mexico, a magistrate judge would there'd be a county level magistrate, this is my understanding, would not have jurisdiction over a federal offense, a violation of federal law, which a violation of a CFR Code of Federal Regulation would be a violation of federal law. You would have to be charged with a violation of federal law in federal court, prosecuted by a federal prosecutor, not be in a county court in the state of New Mexico, a state court with a state law. That's why. That's why.
Charged with trespassing. And the point is, you know,
Why am I charged with trespassing? Well, because let's look at this. All right. So this is what I think and what Blair thinks he's most likely actually charged under. I realize that it says that that C as well, but let's deal with C first. How about that? Let's deal with C first. So C is criminal trespass also consists of knowingly entering or remaining upon lands owned, operated, or controlled by the state. Who is the state? Well, this is New Mexico. So the state would be New Mexico or any of its political subdivisions. And a political subdivision of the state of New Mexico would be counties, cities, maybe something else. I don't know. But, you know, maybe there's a New Mexico Department of Parks and Recreation or something like that. I don't fucking know. But that's what they're looking at. The federal government is not the state of New Mexico, and the federal government is not a political subdivision of the state of New Mexico. So C would not work. And I don't know if B would work, but B is much closer to being able to work. Criminal trespass also consists of knowingly remaining on the unposted lands of another, knowing that such consent to remain is withdrawn by the owner or occupant thereof. So what the state would have to prove would be that the owner or occupant withdrew consent for Lane Meyers to remain at that spot. Now, I want to point out one fun fact is that Lane apparently has a shit ton of legal problems and he gets in trouble all over the place all the time for all sorts of shit. And that's not normal behavior, which is why I think he is not right emotionally, psychologically. You fill in the blank there, but normal people can go camping and not end up trespassed. Normal people can go other places and not get in fights or whatever. He was saying that Westlaw says B doesn't apply to public land, but that's what he said. Take that with a grain of salt. So B would not apply to state or local or county or any political subdivision of New Mexico's public land. Does it apply to federal land? Maybe. Well, good for him. All right. Oh, back to this. So what the tactic that I believe that Dunn is going for is to show that the whoever said to the police that Lane Meyers is trespassed did not have authority to do that, and therefore he wasn't authorized. He wasn't acting for the owner, and he wasn't the occupant. So basically what I think Dunn's tactic is to say there is no CFR, there's no Code of Federal Regulations that authorizes this. And so it is an unauthorized action taken by the whoever did the trespass. And so we've eliminated an element. The consent wasn't withdrawn by the owner or an agent of the owner because the person who did it wasn't authorized to withdraw that consent. And so there can't be any criminal trespass. I think that's where he's going.
You can be charged with trespassing based upon a CFR.
Violation.
On the determination of a CFR violation, they have a lawful right to exclude you from Forest Service property.
Yes, along with, I just went through this.
Hold on, don't interrupt. And if they have a lawful right to exclude you from Forest Service property, then what Officer Moreno did is correct.
No. It has to be CFR.
I believe that is Dunn's argument. I wouldn't take that, what Dunn just said, as gospel. I don't know that that's the case. It could be a violation of policy, could get you excluded or banned from the property. It could be something where the CFR says you can't violate this particular. If you violate any lawful directives of staff or whatever, and they have a policy that you can't do X, then that might be, you know what I'm saying? Like, so this is Dunn's version of his argument. So take it with a grain of salt.
I just went through this out here. I would have had to get charged with that CFR, that threatening one, and been told to leave.
That is not true. All that has to happen is they have to revoke your permission to be on federal land.
Who does?
I'm doing the other side of that. You're fucking wrong.
Who does? Who has to? Who has to do?
Somebody with the authority of the United States.
Yeah, somebody with the authority, like a Leo, USF.
So we have to argue for the CFRs and federal law.
Someone with the authority, right? This guy is Lane thinks he's so smart, but what Dunn said was someone with the authority. Lane said like a Leo. No, someone with the authority. Again, Dunn's argument is that if there's no Code of Federal Regulations regulation that justifies or authorizes the camp manager or something. I'm not really familiar with all the underlying facts. I don't really care about them. But the person who trespassed Meyers, if there's no underlying CFR that they could point to that gives them the authority, then there you go. And it'd have to be a violation of one of those CFRs, which could be as much as or as little as a violation of policy or a violation of the order or directive of someone, if that makes sense. So it doesn't have to be a Leo to trespass you. I think maybe Meyers is getting confused between being trespassed, i.e., a person with the authority to trespass you saying you're no longer welcome here, and being actually physically removed by the cops or arrested for it, like a criminal trespass citation that you have to go to court on, or else you're going to go to jail or get a bench warrant for non-appearance, etc.
Law that Doug Downing did not have authority to trespass you.
But hold on. But I don't understand why you guys should just go to the fucking deposition where I literally interviewed him for 15 minutes asking him about that CFR. Did I violate it? I spent 15 minutes on CFR 263 in the deposition with Doug Downey, got him to admit that I did not do any of those behaviors, and he even admits he didn't have the authority.
What is CFR 263? He's missing part of it, which is why I'm asking. 32, no, 49 CFR 263, 8 CFR 263. Anybody know? Let's look to no one knows what CFR 263 is. Okay. Parks. Title 36 CFR. Let's try that. 36. Let's see if I don't see anything coming up. I don't see a 236. Anybody have an idea what CFR he's talking about? Just make sure he said 236.
263 in the deposition with Doug Downey. Got him.
If I talk faster, I'll be able to say everything I want to say before I get interrupted. 263. All right. What else could it be? If it's not that, what else could it be? So one says Title 50, Wildlife and Fisheries. Okay. We can do that. I don't see a 50 CFR 263. 36 2.33. Title 36 2.33. All right, so we're at Title 36. .33. I have a report of injury or damage. 2.33. Title 36 2.33. Title 36 2.33. Report of injury or damage. But we're getting off the topic. The topic is what did Lane talk to him about? And I don't know what Lane talked to him about. Maybe it's 2.63. No, there's not. There is not 2. Well, is there a 2.63? No, there's not a 2.63. .31 is trespassing and tampering. That's if it's not open to the public. Oops. So if it's not open to the public, it is, I would assume, if he was on a campground or a camp, whatever, it's open to the, maybe it's not, I don't know. It has to be with physical contact. I don't know. It would be interesting to see what CFR Lane thinks that he was talking about.
Admit that I did not do any of those behaviors, and he even admits he didn't have the authority. His intention was not to have me arrested. He admits I did not violate 263, and he had no authority.
He says multiple times, like he thinks this is a winner. The question is, though, not what he thinks, but what the state can prove. If the state can prove that he was the owner or occupant, and by owner, I'm going to assume that an authorized agent of the owner would be sufficient because that's pretty normal. You don't have to have the owner come out and trespass someone from like a store. The tie is dope. He smokes dope, but I don't think that tie is dope.
All right, I see you. I feel you. Because Doug Downey even admits I didn't
Dunn was like, save it for trial.
Violate 263 right in the fucking deposition.
Again, at trial, we're not at trial.
That's what I was expecting. I was acting like we were at trial, and it was like, my bad. Dude. I know. My bad.
It was a motion to suppress. Okay, so I was right. It was in fact a motion to suppress.
We have to accept their facts as accurate.
The state's.
So apparently they have to accept the state's facts as accurate. 263 subpart 2808. What the fuck are you talking about, homeboy? Doesn't make any sense.
Problem is, they're wrong about the law. This is a mistake of law. Read the second amended complaint I put in there. This is a mistake of law, and it influences whether or not his suspicion is reasonable.
Moreno.
Suspicion is reasonable.
Hold on. What second amended complaint?
Second amended complaint I put in there. This is a mistake.
I'm going to slow this down because it sounds like he's talking about a second amended complaint, but he is a defendant here, so let's listen close.
As accurate.
The state's.
The problem is they're wrong about the law. This is a mistake of law. Read the second amended complaint that I put in there. This is a mistake of law, and
second amended complaint that he put in there. I don't know what that means. Maybe the second amended motion to suppress
influences whether or not his suspicion was reasonable.
Moreno's
suspicion is reasonable. Hold on. Is dependent upon whether or not Doug Downey, under the CFRs, had the authority to trespass here.
See, this is, I don't want to nitpick Dunn but this is his case. He's gotten so far as to actually apparently allegedly draft a motion to suppress. He's trying to attack reasonable suspicion, and that doesn't make any fucking sense because an arrest was made. So you need more than reasonable suspicion, you need probable cause. And even if it is a mistake of law can justify, or you can justify arrest. You can justify probable cause or reasonable suspicion with a reasonable mistake of law. That's Hein. Reasonable mistake of law. So it's all about reasonableness. Well, I guess this is for the so they're talking about probable cause here, but then they switch to I guess the underlying facts here were, I thought there was an arrest because they stopped him. They justified the stop with the tail light. But anyway, you can make a reasonable mistake of law. How about that? I'll just say it, and you can double check me on that. He can make a reasonable mistake of law. So I don't really understand exactly what Dunn is going on about here, because from the cop's perspective, the cop doesn't have to know about CFRs. The cop has to have reasonable suspicion that the guy he's talking to, who says you're trespassed, has the authority to trespass you. And if that guy is a camp, what is it, a camp manager or something like that, whatever they've said this guy is, if this guy works here, this guy probably has the authority to trespass you. I think that would be very probable. So I don't know that you're going to actually suppress that based on a reasonable mistake of law. I don't think a state cop has to know the Code of Federal Regulations well enough and do an investigation on whether or not someone is 100% authorized to do this before he actually just acts and arrests you. Okay, so yes, but you have to understand the crime he's arresting someone for. Let me help you out here, brother. This is the crime he's arresting somebody for. He's not arresting somebody for a violation of a Code of Federal Regulations. He's arresting someone because someone who appears to be the owner or an agent for the owner or authorized by the owner has said Lane Meyers is trespassed from this property. I am just as worried with Lane as I was with every other person who threatened to sue me, including the people who have sued me. So there you go. I've also not been successfully sued. How about that?
And I have a recorded call with the fucking head of the Southwest fucking division, the highest ranking law.
The record in front of the court, and I don't know that person has the authority to say that or not. The regs are the authority. The regs are the only authority here on what the regs say. I don't need anybody else's interpretation of the regs. It's just the regs.
I mean that I have the command.
Well, technically, he needs the magistrate judge's interpretation of the regs. And technically, he also needs any other courts that have interpreted those in New Mexico, because he's in New Mexico State Court. And it would really help him if he had any other federal courts that have interpreted those regs. So he doesn't need them, but he does need the magistrate's interpretation of those regs.
Commander of the Southwest Forest Service saying Doug Downey did not have that authority.
Your interpretation of the regs. We're going off the plain fucking black and white language of the regs and nothing else.
I'm saying along with that, I'm saying the Forest Service agrees with you. The Forest Service is on my side in this. The Forest Service agrees that with you in your position, as well as Doug.
So here's the problem that Lane is not getting. The Forest Service isn't suing him. The Forest Service isn't prosecuting him. Even the federal government isn't prosecuting him. If the federal government was prosecuting him, this might mean something. But the federal government is not. There's a concept in the United States called the separate sovereigns. So New Mexico has sovereignty over New Mexico, and the federal government has sovereignty under the federal stuff. So a New Mexico court can't tell the federal government what to do or how to prosecute its cases. And within very limited exceptions where a state violates the Constitution, the federal government can't tell the state how to prosecute its cases. But right now he's in a state court. And so no one in that court gives a flying what the Federal Park Service says. At the time, the question is, are the elements in the New Mexico statutes at the time, was the person authorized to act for the owner of the government? Did they act for the owner of the government by notifying Meyers that he was no longer allowed to be there? And if they did, and he stayed there, well, now he's criminally trespassing.
Downey doesn't qualify for one of those names in there. And before I said anything about a lawsuit, they were fucking feeding me information left and right from the Forest Service. They said, Doug,
the stuff you have in writing that I want.
Okay, I have it on a recorded call too. Canuto Molino.
I wanted a recorded call. That's it's called hearsay. I'm not doing that.
I get what you're saying.
It's not admissible.
Well, I mean, he knew the call was being recorded.
So this again, we're going to what a layman thinks is the issue and what the attorney said. The attorney said, I don't want the recorded call. The recorded call is hearsay. It's inadmissible. It's an out-of-court statement offered in court for the truth of the matter asserted therein. Because again, Lane is saying, this guy said, I didn't commit these things. And I want to offer it in court to the judge, to the trier of fact, that this means that I didn't do these things. This is an out-of-court statement offered in court for the truth of the matter asserted therein. Hearsay, textbook definition of hearsay. So Dunn says, I don't want that. That's hearsay. I can't do anything with that. I've got to actually have the guy in court to do it. What is Meyers here? What is Lane Meyers here? Lane Meyers says, oh, well, he said I could record it. Well, no one fucking cares whether he said you could record it. At this point, I don't believe in New Mexico that Dunn would have a obligation to narc on his client if his client had wrongfully or illegally recorded a phone call. So Lane doesn't care, or Dunn doesn't care, but Lane doesn't understand. See, words have specific meanings. Dunn said a specific thing. Lane is not educated or smart enough, mostly educated enough, knowledgeable enough. How about that? Is not knowledgeable enough to understand the specific meaning of the specific words that Dunn used. But he thinks he's smarter than Dunn. He thinks he's more knowledgeable than Dunn. It's so frustrating.
He agreed to it. That's what it was like a deposition unofficially. I'm telling you, it wasn't.
There's no such thing as an unofficial deposition. Depositions require certain things. There has to be a deposition officer there. If it's recorded or if it's videotaped, there has to be. Well, maybe I'm applying California and federal rules, but I'm sure that New Mexico has specific requirements for a deposition. So, and I doubt that anything that Lane Meyers did would qualify as a deposition. I mean, in theory it could, but I would highly doubt it. Because one of the things that is normally required, and unsworn deposition, yeah, but one of the things that's normally required in a deposition is opposing counsel also gets to be there, and they get to ask the deponent questions. So if you're deposing a witness, you can't just ask leading questions that you think, because you don't know what the fuck you're doing. You think that, oh, if he says yes to this, then I must be innocent or whatever. But then opposing counsel gets to be, then opposing counsel can ask the question in maybe what we like to call a right or better way that will actually get a answer that's closer to the truth. So was opposing counsel there? Oh, and object to questions, yeah. But regardless, and even then, depositions are generally speaking, not admissible in trial except under certain limited sets of circumstances.
Send it to me, but I have no way to certify who that is. They're not under oath.
Oh, before you, I was going back and forth with Albuquerque for 2 months with the commanders down there, and they were emailing me stuff, and the GSA, and all of them are on my side saying that.
Nobody's on your fucking side, Lane. Nobody's on your side. I just have to be honest with you, Lane. Nobody's on your fucking side. The federal government has not filed an amicus brief in your case saying that you were wrongfully trespassed. Could they? Absolutely. Do we have hundreds and hundreds and hundreds, maybe thousands of attorneys working for the federal government who are qualified to write such a thing? Absolutely. But they're not doing it. So explain to me how they're on your side, Lane. I mean, you're hearing what you want to hear. I can believe it. Almost always people hear what they want to hear. It is maddening as an attorney because I've been trained to think in a certain way, and I hear the exact words that are coming out of someone's mouth. And I react and I catalog those words. You said X. These are the specific words that are coming out of your mouth. But most people hear a feeling about things. And they answer the question that they feel like you asked. And the other side will hear the answer given that they feel like was given. Oh, you said you would do this. I never said that. I actually said this. No, you said this. Well, how do you get those situations? It's because one person asked a question the other side didn't actually hear or respond to. They responded to the question that they thought was asked or wanted to be asked or felt like was asked. Like, I'm not trying to throw my wife under the bus, but a lot of times I'll say things to my wife like, hey, did you feed the dogs? And she'll be like, oh, I was going to go buy dog food. And I'm like, that's great, but that's not what I asked you. I didn't ask you if you were going to buy dog food. I asked you, did you feed the dogs? You answer the question that you felt like I was asking. You didn't answer the question I was asking. I mean, when you actually stop to listen to conversations people have, you'll find that is almost universal. That people don't actually respond to the specific, they don't hear the specific words, and they don't always respond to the specific words. Well, because your assertion isn't true, Bruce. You must have studied at the feet of the almighty gospel giver, Eli, who makes PowerPoint presentations and presents those PowerPoint presentations as though they were citations to some authority, but in reality, they're just PowerPoint presentations that he made that say what he wanted them to say. We have a lot of instances where people get arrested for being trespassed from federal property. There's the guy from Maryland who what is it, Angry Vet or something like that? He actually tried they don't have jurisdiction, but there is such a thing as concurrent jurisdiction. Is he joking, Alpha? All right, well, if he's joking, that's fine. But maybe there are people out there who don't understand this. But there may be exclusive jurisdiction. The federal government may have exclusive jurisdiction, and there may be concurrent jurisdiction. That is a question that would be a great question for Dunn to have asked. Required the prosecution to prove that the state had jurisdiction over making a trespass in that on that particular land. That'd be a great question. And if the state didn't have jurisdiction, that would be an easy way out. But it's my understanding that most places are going to have concurrent jurisdiction. Most places are. The federal government doesn't spend money law enforcement to patrol a lot of these places.
Okay, who's on the other end of the line from you? It could be your friend.
No, I mean, I have it in writing too. I'm saying I have it in writing with their official emails.
So this is by saying one, you're implying that it actually went to trial and he proved everything. If they're settling, if they're arguing on a settlement amount, that means they haven't won. That means that they're doing negotiation for settlement. If they can't agree on a number, the case is going to continue to trial, and at trial, then he may win, he may lose, whatever the case may be. What he won was, I believe, a motion to dismiss, if I remember correctly. And finding out that both officers have been disciplined for actions doesn't mean shit. It doesn't mean that you're not innocent or you're guilty or not guilty or that you have a valid cause of action or don't have a valid cause of action. These are immaterial things that non-attorneys think make sense or that mean something when in actuality they don't. I have literally been involved in cases where, and I guess Bruce was in fact joking, so there you go. I have been involved in cases where there was specifically no liability. There was a case that I was involved in where an elderly woman tripped on a crack in her sidewalk that in front of her apartment, and she got messed up, like obliterated. She fractured her ribs. She broke a rib. It punctured a lung. She had to spend a lot of time in the hospital. She was all bruised up. She was messed up. Now the sidewalk was less than a half inch. The crack was less than a half inch variance between one and the next. And there's a law in California, there's case law that cracks with a variance under a certain size are de minimis. And there's no cause of action, there's no liability if you trip on someone's sidewalk where the variance is less than, I believe it's about an inch, if I remember correctly. But in this case, in the case that I was involved in, I wasn't the lead attorney, but in the case I was involved in, it was less, it was like a half inch. It was much less than an inch, right? And I knew that there was no liability. And the attorney, the lead attorney was like, well, we're going to see, we're going to make them prove it. We ended up getting her, and I say we, meaning, I just wrote pleadings and stuff. It wasn't like I wasn't controlling the case at all, so I don't take any credit for it. But the firm I was working for got her something like $40,000 or $49,000 or something like that for where there was zero liability. And you're going to say, well, why? Well, because they did the math. And maybe they got it wrong. Maybe opposing counsel got it wrong and miscalculated how much it would cost to do a demur, basically a motion to dismiss. Because we literally pled that the crack in the sidewalk was, less. I mean, so maybe there would have been a factual issue that would have had to gone to trial, but essentially there was no liability and they still paid out. So saying that someone's going to settle doesn't mean that they're accepting any liability or fault. It's just saying that they've done the math and they're like, well, it's more cost effective for us to hand someone money to make them go away than it is to fight this all the way to the end. Because if we fight this all the way to the end, even if we win, we'll have paid our attorneys more than that. Right?
Their .gov.
The recording is not helpful because I have no way to authenticate who's on the other side other than your word. No,
I'm saying I have an email. I'm going to get you this right now. I have an email from them saying I did nothing wrong. I am not banned. I should have never been banned.
Banned is different than trespassed. Banned is different than trespassed. And saying I should have never been banned, let's just say that they sent an email saying you should have never been banned. What does that indicate? If I say you should have never been spanked, that indicates that you were spanked. Good job. Good job. You get a cookie. So if they have an email saying you should have never been banned, what does that mean? It means you were banned. So if the officer arrested you for being trespassed, let's just assume that banned means trespassed, because because Lane is misusing words. If you were trespassed and the government says you shouldn't have been trespassed, it implies that you were trespassed. So the cop had probable cause to arrest you because at the time that he arrested you, you were, in fact, trespassed. Now, again, maybe some argument could be made that you were wrongfully trespassed and that the person didn't have. So really, you have to go to did the person who trespassed you wrongfully, assuming this was a trespass and not banned, whatever. But let's just assume banned means trespass. Assuming the person who trespassed you wrongfully didn't have the authority to trespass you, you're going to have to prove that. Now, do the email say that the person who trespassed you didn't have the authority to trespass you? I mean, if it says, if the federal government issues something that says the person who trespassed you didn't have the authority to trespass you, that's something. That's something. But again, what's the problem with that? The problem with that is it's an out-of-court statement offered for the truth of the matter asserted therein. Is there some exception for it in New Mexico law? I don't know. But it would be a lot better and a lot cleaner if the federal government would just file a brief. Here's the problem, Johnny. If you're causing problems to the point where you get trespass from someplace, that means you're causing problems. And just because there are no regulations currently that prevent that, and maybe he doesn't get found guilty, great, good for him. He shouldn't be punished for violating some sort of law that, wasn't in effect or whatever. I can understand that. But what is going to be the end result of that? The end result of that is going to be, there's going to be something put into place. I almost guarantee you, there's going to be something put into place that's going to ban that specific behavior. So by allowing people and by championing people who act like shitheads in public, there is a counter push. There is a, the pendulum swings back against that. And what you end up with are more laws and more restrictions on what you can do in public. So, I mean, I get what you're saying, but, there is a penalty associated with him winning. There's a penalty for society for him winning.
Doug Downey handled it wrong, and they're going to handle it internally and punish Doug Downey because what he did was wrong. I was not.
Well, that would be interesting if they said that they were going to punish Doug Downey on an internal email. That would be weird. I would assume that would violate Doug Downey's privacy rights if they're talking about what they're going to do to a third party.
And I'll review the email and I'll put it with the regs and we'll put it in front of the court, but I need it and I don't need anything else.
I feel you. No.
If it's not in writing, I don't want it right now, Lane.
Yeah, and then once they realized I was trying to trick them to get a deposition, they're like, all right, that's all we're gonna say.
He was trying to trick them to get a deposition. This dude doesn't know what the fuck he's talking about. He's the same CRS everywhere. Colorado revised statute. Yeah. I mean, free speech is great, and it's really great for what it was intended for. But people have found out that there's an audience for people acting like assholes and getting away with it on YouTube. And now we have people being assholes just to be assholes, just for the clicks and views, and not really. I mean, you might want to think that people are fighting for your rights and freedom. And I would love to think that too. But think of how many times these things actually go to the point where they get case law established. Think about that. We hold up Turner v. Driver. He's the only one that really has done anything like that and has got it's solidified in the Fifth Circuit that you have a right to record police subject to reasonable time, place, and manner restrictions, right? But he was suing for money, and he stopped suing because all of the money was gone. He lost the appeal on all the real issues, the Fourth Amendment issues, but the First Amendment issues, and he lost on that too, I think. No, he won on one of them. But on the First Amendment issue, the court said, basically you have no cause of action because qualified immunity applies. But now we're setting it in stone. Now the Fifth Circuit has made it clear that you have a right to record police in public, subject to reasonable time, place, and manner restrictions. So I've been following this particular genre since 2013 or so. I mean, there's a reason why I've got, stuff from Pink Camera Magic and Ida Foxy Queen and stuff like that. Like, I've been following this stuff forever, and there has been no real change. There's been, I really think that with the slight exception of Turner v. Driver, we've only had really negative change. Only negative change. There's only been an increasing in restrictions and a narrowing down of your rights. So you gotta judge a tree by its fruit. If you're biblical, if you're not biblical, the purpose of a system is what it produces, is I think the non-biblical version. So everything that all these guys do, everything that like Springer does, everything that like DMA does, everything that Long Island Audits does, everything that Rogue Nation does, I mean, everything that all these guys do ends up with negative benefit. There's no benefit. There's just someone who acted like an asshole and maybe got a settlement out of it. So maybe they got a little bit richer and they got clicks and views. And, there's a whole like parasocial economy built up where the anti-auditors, anti-frauditors, where they make their dollary dues. The police response was very different. Well, nothing has changed on that. You still, I mean, fucking like you still get, you're not gonna educate all the police one at a time, dude. Like, get real. And there's and you run into other people who like have their lives ruined. Like, there's this one guy who posted on one of my videos. He audited the front gate of Fort Dix something or the other. And he's charged with 18 USC 795. I think that's how I found me, or 759. I forget which one it is, but the one that says you can't record a vital military installation, right? Now the charging document was just pure shit. It says that he was recording in violation of that particular statute without permission of the base commander, but the base commander can't give you permission to violate 18 USC 795. So it doesn't make any sense, but he's being charged with a violation of 18 USC 795. But there is another one, the 50 USC, I forget what off the top of my head, but basically says if you're on base and you do something that violates the order of the base commander, then there's a charge associated with that where you could do up to like a year in jail. And he was on base when he was like, he didn't look at the plot maps, and he was actually like way on base. Like the base gate was like, maybe a third or a mile or probably less than that, maybe an eighth of a mile in on base property. He was way on base. So, yeah. Well, I mean, I guess you can get residuals if actual live people ever watch any of his old stuff, but this guy's gonna get fucked, because I mean, they might have the wrong section of U.S. code listed on the charging document, but they could always amend it. Was he on base when he was filming? Yeah. Did he film in violation of base policies? Sure. You know, it's like, it's sad. You know, people see these. I think there's a lot of negative because people will see like the professional auditors go out there, you know, guys who know what they're doing, they know where they are, they know their boundaries. Maybe they're even working with an attorney like Jeff Gray and knows the edges that he's trying to push. And so he goes out there and he's like just on the safe side of the line, right? And other people go, they see this and think, well, that's, you know, I could do that. And they go out there and they push it to the other side of the line. And next thing you know, their life's ruined, right? How many startup auditors have had their channels, like they make one audit where they get arrested and they don't make any more, right? What happened to them? Well, they got fucking hemmed up, bro. Like it cost them money. Maybe they got a conviction. Maybe they pled or whatever. Like it fucked them up. This is a negative community. It really is a negative community. There's no benefit from it. Anyway, back to the topic at hand.
You know what I mean?
I don't care. I really don't care. All I care about is what I have in writing for this motion to suppress at this point.
Specific to that. The other stuff would be more for trial, you're saying?
The recording would be something we might use at trial.
No, I mean, he'll come testify.
Well, then we're going to have to subpoena him for testimony.
Oh, yeah, he already agreed to all that.
But hold on. You want to do all this work if the in writing and the regs say that it requires an officer to have authorization to trespass somebody from federal ground, then we have what we need for the record.
For sure.
And she set it up. I got her to set herself up to say, well, provide me that reg that says that. So we're going to provide her that reg, and we're going to color it with the email that you say you have, the writing.
So there's a reg that says,
well, then we're going to have to subpoena him for testimony.
Oh, yeah, he already agreed to all that.
But hold on. You want to do all this work if the in writing and the regs say that it requires an officer to have authorization to trespass somebody from federal ground.
Officer authorization trespass federal. Officer authorization trespass federal. Where are we at? Anybody have any idea what we're he says they have a regulation. $92.30. $92.30. I don't know what I'm not seeing. don't see anybody. We're not looking for state trespass law. And this is New Mexico. New Mexico state trespass law is 30-14-1 is criminal trespass. This is pretty easy. Not all parts of military bases are blocked off from access to the public. So the gates usually prevent you from going into like sensitive areas, but like a lot of times bases will have like base housing outside of the gate, but on base property. So I mean, it's just like it looks like a residence, you know, a residential neighborhood. Yeah. Anyway, I don't know what reg he's talking about. Wouldn't it be great if we knew what regulation he was talking about? Department of the Interior, looks like land resource, mineral preservation, conservation. Maybe what was that? 263? What was that? What was that? Regulations relating to public lands. I don't see anything there. I don't see anything there. Anyway, if someone ever does come up with the regulation that he's talking about, yeah, Papa Sanser, I know that 263 is what he was rambling about earlier, but 263 is an incomplete citation. And I can't find any CFR that ends in 263 that deals with this particular issue. I would assume it would be in Title 43, the Public Lands Interior. But I don't know. Did my browser just lock up? No, just that one page, huh? Well, I'm going to close that. Interesting. All right, so I guess let's continue on.
And we have what we need for the record.
For sure.
And she set it up. I got her to set herself up to say, well, provide me that reg that says that. So we're going to provide her that reg, and we're going to color it with the email that you say you have, the writing you say you have from them, and we're going to put that in front of her. And then we're going to go in and we're going to say, look, he didn't have actual authority. Lane was still lawfully on the property. If he's still lawfully on the property, it doesn't matter whether the Forest Service or the state police can patrol on Forest Service ground. They can only enforce state crimes.
Hold on a second. I was Googling 43 CFR 2920.1. 49 CFR 2920.1. 49 CFR 2920.1 or 0.12. That has to do with like using public lands for like mining or timber or something like that. Anyway.
On the property. If he's still lawfully on the property, it doesn't matter whether the Forest Service or the state police can patrol on Forest Service ground. They can only enforce state crimes.
I just don't understand.
And the trespass statute was a state crime.
The argument how she's saying that why are we analyzing the CFR if I'm not charged with that? Are we saying that this because Doug Downey's not saying that I violated the CFR and that's why he wanted me gone? He's saying I didn't pay.
It depends on the outcome you want, Teresa. If you want to get a lawsuit, maybe you shouldn't stay. If you want to get arrested and be able to post stuff up on YouTube, maybe you should stay. If you don't want to get arrested, if you don't want to find out, if you don't want to fuck around and find out, I think you should leave if you're told you should leave. That's the safe thing. If you're told to leave and you leave based on being told to leave, you could always talk to an attorney afterwards and say, hey, do I have a cause of action? And then you could sue based on that. But yeah, if you're told to leave, my recommendation would be to leave. Fight them in court. Don't fight them in public.
Not that I violated. I don't understand where this CFR about threatening and all this shit came in. If we brought it in, I don't understand why. Doug Downey never brought it up. Doug Downey never said I threatened him. Doug Downey said I didn't pay.
Clearly not what the recording showed. That no, you know this. He told Moreno that you were threatening and that you had let your dog loose.
No, he told 911 that.
Yeah, right.
But when Moreno came, he said something different.
These are all evidentiary issues that he's trying to get into here. All right, he says Moreno trespassed Lane on 911 camp post, saying he was attacked by Lane's dog. Later changed they were aggressive, but there was beware of dog sign up, which Doug ignored, then pulled pepper spray. Okay. These are evidentiary issues that are outside of what we're talking about now. So all of this can be, well, the changing story, alleged changing story can, in theory, be used to impeach Doug. I'm not entirely sure that you could keep an aggressive dog at a campsite, even if you put up a beware of dog sign. If Doug pulled pepper spray, that's not against the law. Anybody can pull pepper spray. It's whether you use it or not. I mean, it's not a firearm. It's not a deadly weapon. So I don't know. Like you keep saying things, but I don't know if you think that they're relevant or if you think I need to know. But they're not relevant.
Inconsistent statements does not mean that it's dispositive.
See right there. Dunn's like inconsistent statements, right? So Dunn saying like, maybe impeachment later.
Positive. Lane, you're not a lawyer. You're trying to argue points that are not going to help you.
I just don't understand how we're talking about the CFR. Why did we bring up the CFR if it doesn't apply? I'm not accused of it.
That's how you get to whether or not Doug Downey had actual authority.
But Doug Downey.
See that question asked, question answered. Why'd you bring up the CFR? Because that's how we get to whether or not Doug Downey had actual authority. Easy peasy lemon squeezy. That's question asked, question answered. Now here's the argument. Now homeboy is going to argue.
Downey didn't accuse me of violating that CFR.
He tried to trespass you.
No, but that's not what he said in the deposition. But that's not what he said in the deposition.
All right, so we've got 36 CFR 261.3. 36 CFR. Haven't we been there? 36 CFR 260 36 CFR 261 prohibitions. Interfering with the forest officer, volunteer. Okay. Threatening, resisting, intimidating with any forest officer engaged in the encounter on the performance of his official duties. What is forest officer? What is a forest officer defined as? That was not useful. So this is 261.3. Oh, volunteer. There you go. I think aren't camp counselors or whatever, aren't they volunteers? But this isn't where he was talking about trespassing. See, he wasn't charged with any of things. Occupancy and use. I don't see anything in here that does it. And we're not, no. So that section is dealing with like people who are like engaged in timber operations or mining operations, things like that. It's in chat. Someone listed as verbiage. I don't know. I don't know what we're talking about. Anyway, all right. Well, let's get back to this.
Position and
Tried to trespass you.
no, but that's not what he said in the deposition. But that's not what he said in the deposition. In the deposition said he didn't. He just wanted me to. He told me he just
Deposition doesn't matter for shit. It's what you were charged with, whether or not the officer had reasonable suspicion.
to charge me with the CFR.
That hurts me, dude. Done. He doesn't need reasonable suspicion to charge you. He needs probable cause. He needs probable cause to arrest you. He probable cause.
But no, to charge you with trespass, but she would only have authority to charge you with trespass if the CFR supported that Doug Downey had the authority to exclude you from federal property.
Well, then that would go back.
Okay. All right. There's been no testimony given, handyman. So again, like, you know, I'm not trying to be a dick, handyman. You're saying things that don't make any fucking sense. I don't think there was an actual deposition done because this was in a phone call that that Lane's counsel has said basically is hearsay. So I don't know. Like, I don't think a deposition is a specific thing. If there was actually a deposition of Doug, then Doug would have given testimony in a deposition. But if there was not all the formalities involved, then there was not a deposition. Talking to Doug over the phone and telling Doug, hey, I'm recording this is not a deposition. It's not a deposition. He's not under penalty of perjury. Everything he said is hearsay. There's no exception that I'm aware of because he's not opposing counsel, or I'm sorry, opposing party. You can use statements by opposing parties. So anything that Lane said in that phone call could be used against Lane, but nothing that Doug said can be used. It would have been hearsay, even if it was recorded. So I don't know what you're trying to say, handyman. Like, you it's nonsense.
Back under C because then they can't charge me. No, because if it's on, if you controlled, I already went over this, owned, operated, and controlled. Section C applies to that then.
Again, Section C does not apply because Section C is for state, not federal. The state doesn't really have authority to make rules regarding federal land.
And I'm done.
They,
You're not gonna listen. I'm gonna be done.
I'm trying to hear why you.
I'm trying to hear. No, you're arguing. You're not trying to hear. You're trying to argue. It's 90% of my body weight.
Why you think that it doesn't apply?
You're arguing why I'm wrong, and I'm telling you I'm not, and I'm not going to argue about it.
I'm not arguing that you're wrong. I believe when the state amended the charge, they.
I'm not arguing that you're wrong, and then proceeds to argue.
Hold on. I don't care what you believe. I am telling you the only things that matter, and the reason we can talk about CFRs is we have to in order.
So the state amended the charge, and that's why I believe that. That's why I personally believe that Dunn is right, and it is this 34.1b and not this 34.1c. I believe Dunn's right.
To address who has actual authority to exclude somebody from federal lands. If nobody with actual authority excluded you from federal lands, then you were still lawfully there. If you were still lawfully there, then he doesn't have probable cause.
But that falls under C.
That's what Dunn said, matches my understanding. It makes perfect sense. Lane. Okay. So Lane did have a deposition with Downey, the prosecutor, then that would be testimony. So I take back what I said, handyman. I apologize. Mea culpa. If there was, in fact, an actual deposition with Downey and with the prosecution present, with an actual like court reporter and all that fun stuff, then you're right. I'm wrong. but admitting it didn't have any of the elements. It was a dog's not moving camper fast enough. Talking back about being a public landowner. All right. Well, the fun thing is that the state is the victim, right? So the state gets to show that. Well, no, hold on a second. Let me think about this. So the state has to show that he trespassed him. That's what the state has to show. And then he had authority to trespass him, or parent authority to trespass him, because that's the kicker. Did you hear the talk about apparent authority? Where was it talk about apparent authority? Let me see. Hold on a second here. Is there a didn't they normally have a transcript? Show transcript. That it? Okay, so it is actual authority. All right. So it's not apparent authority, it's actual authority. Interesting. I wonder. That would be an interesting thing to look at. For me, interesting. For you guys, maybe not so much. Scholar, let's go to New Mexico. Let's go to New Mexico. New Mexico. Authority trespass. Interesting. So it doesn't look like the state of New Mexico has an apparent authority doctrine. But I don't know if that would really apply to trespass. Apparent authority doctrine is for consent. Let's do apparent authority trespass. Huh. It sounds like he did it pro se. I'm sure he asked all the relevant questions, and he asked them in a form that is going to make them admissible, etc. I don't know. I don't see anything definitive on Google Scholar in a 10-second search. I'm not going to take the time to do more research. I want to say that once again, I am not licensed to practice in the state of New Mexico, so do with it as you will.
Controlling the state land. C. Trespassing under C.
It's under B. You're not aware. B deals with withdrawing consent for land, or the owner of the lands. Who's the owner?
But C under the authority.
Answer questions.
Hold on.
Who's the owner of the federal land?
Federal USDA.
USDA.
Yep.
The USDA is the owner of the federal land. The USDA is the owner of the federal land.
So who has authority as the occupant or the owner of the land to withdraw consent for a person to be on the land?
A federal judge in a trespassing order.
I don't think so. I don't think it has to get up to a federal judge. Under state law, it would have to be someone with either apparent or actual authority to trespass. I don't know which it would be in New Mexico. I should default to what Dunn said. Dunn said actual authority, so I'm going to default to actual authority. So we'll see how this plays out.
Oh, fucking A, that's not right. You know that.
No, it's 100% true.
No, it's not.
You should talk to my wife then, because my wife thinks my.
No.
You should talk to my wife then. So I've heard that his wife is a federal clerk, federal attorney, federal magistrate. I 100% doubt it. 100% doubt it. I'm going to press X it out. And again, you don't have knowledge because your wife has knowledge. Even if your wife did have knowledge, you don't have knowledge just because your wife has knowledge.
No. Listen.
And think about the absurdity of this. Is your wife on the fucking call? Like if your wife was there, let's just arguendo. Your wife's there. She is an attorney. She has actual knowledge of the subject matter that you're talking about. Just because you're an attorney doesn't mean you know shit. Look at Eli. Eli's been an attorney for a lot longer than I have. And he's dumb as a fucking box of rocks. So just because you're an attorney doesn't mean you know what the fuck you're talking about. That's number one. But number two, if she was an attorney, she would still have to fucking be there to say, no, actually, you should look at this case, or you should look at that case, or look at this regulation or statute. Like, none of it makes any fucking sense. His wife is a disability law attorney now. I can't look at her account, so. I'm not seeing any images of him with her pop up, so I'm going to take that with a huge grain of salt.
The Forest Service, under the regs, has the lawful authority to exclude somebody from the property for threatening, harassing, or intimidating a federal officer or any of the rest of the people in there. The federal law enforcement officer can show up to the fucking campground.
Yeah, federal.
The tree cop could show up to the federal ground. That's not a fucking judge. The tree cop could show up to the federal ground and fucking kick your ass off for threatening Doug Downey.
And give you a piece of paper. But he has to do it by giving you a piece of paper to appear in front of the magistrate. Of course.
No, he doesn't. That is not true.
How long can he ban you for it? Are you saying just leave?
It's not in the regs, and the regs say that they can exclude anybody from federal property for doing these things.
So in your scenario, he comes up there and he says, you got to leave. You're trespassing. How long are you trespassing for? How long? When can you come back?
If you've been trespassed, you have to leave. And then if you refuse to leave after consent is withdrawn, then that's another part of the federal reg.
So let me ask you that then.
And fucking kick your ass off for threatening Doug Downey.
And give you a piece of paper. But he has to do it by giving you a piece of paper to appear in front of the magistrate. Of course.
Why would he have to give you a piece of paper to appear in front of the magistrate? You do have I'm obviously not a tree cop, as they called him. But trespassing, I didn't see anything under 36 CFR about a tree cop trespassing you. The penalty is 6 months or fine in accordance with the applicable provisions of 18 U.S.C. 3571, etc. So I don't see anything here about just trespassing someone. But why would he have to give you a piece of paper? A tree cop is what they call a forestry service cop. I don't know. I've never seen any requirement that they issue a piece of paper because again, the trespass is under state law. And so if you're trespassed, you still can go and bring a lawsuit in federal court. Fucking, interesting.
No, he doesn't. That is not true.
How long can he ban you for it? Are you saying just leave?
How long can he ban you for? See, this is the problem. Like, how long can he ban you for? Under federal law, he probably doesn't have the authority to ban you. Under state law, you're trespassed. How long does a trespass last under state law? I don't know. You tell me. But see, a ban, you're changing words.
Leave.
It's not in the regs, and the regs say that they can exclude anybody from federal property for doing these things.
So
It says they could exclude someone from federal property. Exclude from federal property for violation of CFR. Under 36 CFR. I don't see it. I'm not seeing anything. Let me check chat. I don't see anything from chat on it. So I just don't know. I just don't know. It would be lovely. It would be awesome. Just throw it out there. If someone can get me a copy of the motion to suppress or any of the other pleadings in this case, that'd be phenomenal. I'd love to go over them. I mean, I might not do a live stream on them or anything like that, but I'd love to go over them because, like, I don't know. This to me is pretty interesting. It may or may not be interesting to you, but I think it's pretty interesting.
in your scenario, he comes up there and he says, you got to leave. You're trespassing. How long are you trespassing for? How long?
Check state law.
When can you come back?
Check state law.
You have to leave, and then if you refuse to leave after consent is withdrawn, then that's another part of the.
See, the problem is that Lane is asking a question about trespassing when he wants to be asking a question about being banned. And so Dunn is answering the question about trespassing because Lane didn't ask the question about being banned.
Federal reg.
So let me ask you that then. If
you got it wrong.
If he says if he can withdraw my consent, if he withdraws my consent to be there,
if he withdraws my consent to be there, what the fuck does that even mean? If he withdraws the federal government's consent to allow you to be there,
shows up and he says, I'm withdrawing your consent, you're excluded. How long does that apply for?
You're trespassed under state law. It's if you're trespassed under state law, you have to look at it under state law, unless you go to federal court and you file a petition for declaratory relief. I would assume declaratory or injunctive relief, something along those lines, to challenge a ban if you were actually banned.
Until they agree to let you re-enter.
Well, then I didn't get pre-def.
I think Dunn is answering under state law.
Until they agree to let you re-enter.
Well, then I didn't get pre-deprivation due process.
I didn't get pre-deprivation due process. Well, the fun thing about trespass is you get post-deprivation due process. If you're trespassed, you should have an opportunity to challenge it. But just think about it. Think about it this way. If you go onto federal property and you see a no trespassing sign, right? Did they give you a citation for that? No. Are you allowed to be there? No, there is a posted no trespassing sign. Oh, I'm going to have to go. But just if you just think about it in that kind of way, that's how trespassing works. If you want to challenge it, you file a petition for declaratory or injunctive relief. Anyway, it's been real. It's been fun. I got work to do pulling in, so I got to get to work. Thanks for watching, guys. Have a great day.